Have you ever seen a lawyer come into your hearings where you suspected, or maybe you knew, but you suspected that they didn't even read the file?
Oh, yeah. Yeah, I would as a judge, I was proactive, and I would ask representatives, lawyers, I would say, "Well, where's the evidence of a lumbar back problem? Is there an MRI? Is it only X-ray evidence? Where is it? Can you tell me where it is in the file?"
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode.
I agree. I think experience is really important when looking to hire a law firm or an attorney. Uh,
Mhm.
and we'll go from there. So number two we said was communication with
Right.
your law firm and or lawyer. And we're going to talk about that. So maybe you can address that, why you put it up at number two, and then I can go from there.
Okay. I think it's very important, that a client feel comfortable, with their representative when they go to court. And part of that, level of comfort comes from the level of communication that the lawyers had with the claimant throughout the process. And I would say, if you're going, to a hearing in front of an administrative law judge, your case has probably been pending for almost 2 years. We're getting down to 14, 16 months on a few cases now, but frequently it's 2 years or more. And during that time, has a claimant had an opportunity to talk to the lawyer, to talk to the staff? Um, and I think, it really it can make a person feel so much more comfortable going into court. These poor people, honestly, Peter, I talk to them every day just like you do, and most of them are terrified of going to court. They've never had to go to court for anything, and for most of them, the consequences of the hearing are enormous because they're looking at trying to get back on their feet financially. They're in a hole. Um, a communication between the lawyer and the client is so important in building that trust and that comfort level so that when they go to court, they know that their lawyer is going to do a good job for them, and they believe it.
I agree. I think communication is extremely important between a client and the lawyer and the law firm. I want to talk a little bit just about kind of big picture of the communication because it is challenging when kind of along the way to understand what are people's hopes and expectations. Because I do think clients, are very different across the board on what they're hoping to be the level of communication, what their expectations are. Um,
Right.
like you just said, these cases can take 2 years, but I've seen cases take 3, 4,
Yep.
depending on where you're at in the country too. And, if I meet a client that says, "Hey, look, Mr. Evans, I really just need you or your staff or someone to call me once a week, and that's it, just once a week for this entire case." I just really kind of look at them and I say, "Look, as much as I would love to do that, I have to shake your hand and wish you the best because I cannot we cannot call you on a weekly basis, week after week after week after week for the next 2 to 3 years. Um, First, the average wait time at application right now is about 7.5 months. Um, One of the things we've been really working on is proactive communication versus reactive communication. Reactive communication means when someone calls our firm or emails our firm, and we have portals and text messaging, and we look at all different ways to communicate. Our goal is to call back or respond same day, but no later than the next business day. That's our goal. But, some days are heavier than others and it ends up going to the next business day, and we're all hands on deck for that. That's kind of reactive. Proactive is I want the lawyer or the law firm to call me to give updates. And we found a way to do that in our firm where we send updates depending on what level they're at. Usually every 60 days, sometimes 70 to 90, depending on if they're at the hearing level or if they're at the app or reconsideration or appeals counsel. They get a text message or an email from someone that's on that team that kind of updates them on their case saying, hey, look, it's been about 70 days. We just want to let you know, here's what's going on with your case.
Right.
That's like a proactive communication. The other thing too and I feel like I'm doing a sales pitch on our firm, so please forgive me.
No. It's some good information, people. And, it's kind of a good primer for people as to what's reasonable to expect from their lawyer.
Yeah, I tell folks, look, like we're going to update your case along the way. You're going to get an email or a phone call. Not both. Usually we kind of stagger emails and then a phone call every about 60 to 90 days, and depending on what level they're at.
Right.
And one of the things, and I really pride our firm in doing that. One of the things that we look at in communication too is we created something on our website where our clients can log in. You have to be a current client. There's a password. Can log in and literally schedule an appointment themselves that is honored either by one of our lawyers or a non-attorney rep, which is the equivalent of sort of I always say like a nurse practitioner to a doctor that can do hearings and prescribe, like a nurse practitioner can prescribe medicine and talk to you about your case that way too. We have a portal system that goes directly into your case file. You can send emails and messages directly to our case manager. So there's different levels of communication. But I will defend a little bit our colleagues because these cases can take 2.5 to 3 years. It can be like you do a lot of work and you do a lot of waiting. You're waiting for Social Security to make a decision. And so there's not a lot to update when Social Security is, and really it's DDS too.
Right.
When Social Security is taking so long, so, and some people, and I get it, because what you said is absolutely true. A lot of folks, this is a horrible experience for them to go through, and they have a hearing, and hopefully, it's in a year. But it doesn't do them any good for you, Dan, to prep someone when their hearing's not for another 12 months. Because in our experience, it's kind of like, oh, I don't remember what I even talked about a year ago. So
yeah.
Anyway, anything else on that? Communication?
I don't think so. Part of it too is staff. All I'm going to say about that, Peter, is that having adequate staff is very important, and you've got a staff with some very, very good people working, and they're very responsive to the claimants, and the claimants appreciate that. They tell me how much they appreciate that. So.
Well, that's great. We do have a great support team and a great support staff, and but it is constantly training. I do a training seminar on a weekly basis with different folks on different teams where I personally put on seminars in our firm every week, and I do it Socratically, which is I'm calling on staff and they hate it, but I love it. And I'll ask them questions, quiz them. And so anyway, so there's of training. Well, let's move on. We're talking about number 3, and I think this is a really important for our audience to hear from you, because I'm sure you've seen it on different levels, is instead the word advocating. And what
Right.
does that mean to you, and what maybe some examples of that?
Well, so I think every lawyer in a courtroom setting needs to be the champion of their client's case. Now, Social Security is a little different than most other court proceedings. Social Security disability is because it's an inquisitorial process. It's not an adversarial. So adversarial means you've got a lawyer on one side and a lawyer on the other, and then the judge is the arbitrator. And so, you got one side against the other, and yeah, A, B, C, and the other lawyer goes, yeah, but what about? That is an adversarial system. Social Security is inquisitorial, and that means that we're trying to get at what the truth is here. What exactly are the impairments? How severe are they? What is the person's past work? It's a joint effort by the judge and the lawyer to flesh out what the important facts are. So when you go into Social Security disability hearing, you're not going to hear a lot of table pounding and theatrics by an attorney. Maybe a few still do that, but it's we're not in front of a jury, and it's you and the judge and your lawyer and the court reporter and a vocational expert, and everybody's all trying to find out exactly what the facts are. So you're going to want a lawyer who will advocate for you, who will go through all of that medical evidence. Frequently, it exceeds 1,000 pages in a file, a claimant's file, and will point out to the judge, okay, judge, check this out. Look at this, page 47 of Exhibit 2A, whatever. And will actually point out to the judge exactly why that judge should find you disabled. And that's advocacy. And that's a very important part of choosing a lawyer, is feeling that your lawyer will advocate for you.
Yeah. Going to bat for you.
Yeah, exactly. Because you're their only hope, really.
Yeah.
We've seen a lot of cases where people go to court without a lawyer, and it doesn't usually work out very well. Yeah.
Let me ask you about, maybe you could give our audience, like, what's the worst, not using names of lawyers, of course. What's the worst case you've seen or an example where they haven't advocated for their client?
Well, so certainly I saw a lot. And, I wasn't every lawyer's favorite judge, that's for sure, because as you know, from being my court clerk for quite a while, I can be a little bit difficult with lawyers when I'm on the bench.
I would say direct. I didn't think it was difficult.
Yeah, I am correct. And if a lawyer is not advocating for his client, that is going to be a problem. And it's a problem for me because as the judge, I wear a hat where I've got to represent the Social Security Trust Fund. I've got to represent the United States. And I also have to make sure that the client is getting a fair hearing. That's the most important part. The judge needs to make sure that the client gets a fair hearing. And if I felt that a representative or a lawyer was not doing their job, I would tell them, you're their champion here. Where's the evidence? Point it out to me. Some lawyers would kind of smile and, be embarrassed. Some lawyers would get upset and even throw things. We know one attorney did that. But I think it's important that the lawyer advocate for his client, and that they have a right to expect that. And if there's something in their file that their lawyer is not bringing up that they feel is important to their case, they need to find a way to tell their lawyer, don't forget this, or what about that? I always ask claimants, and most judges do too. At the end of questioning, I'll ask them, is there anything else about your case that you want the judge to know that you feel prevents you from working? And then they can say, well, I do have, like, I broke my toe the other day, so I can't walk very well, or, they can raise whatever they want, but it's really the lawyer's job, I think, to make sure that as much of the evidence that's important gets out.
Have you ever seen a lawyer come into your hearings where you suspected, I mean, or maybe you knew, but you suspected that they didn't even read the file?
Oh, yeah. Yeah. As a judge, I was proactive, and I would ask representatives, lawyers, I would say, well, where's the evidence of a lumbar back problem? Is there an MRI? Is it only X-ray evidence? Where is it? Can you tell me where it is in the file? And, I would say maybe 33% of lawyers could tell me that, could answer that question, but there were quite a few who couldn't. And, that's important because the judge he hasn't just got that one case today. He's got 5 or 6, or she has 5 or 6 cases. And we're talking thousands and thousands of pages that they've had to read through. And sometimes they can miss something. And that's where it's up to their lawyer to advocate and say, Judge, we've got evidence right here. It's in the VA records or wherever it is, So,
Yeah, I remember having conversations with not just you, but other Social Security judges when I was kind of when I was studying for the bar, doing hearings reporting, where they'd like, they would turn to me after the hearing and be like, that lawyer did not read the file.
right. Right.
They couldn't even answer a simple question like, what's the alleged onset date? So,
Pretty rough.
yeah, so it's tough. Okay, let's go on to and I think it goes with kind of number 3 a little bit. You talk about advocating, but number 4 we wrote down good reputation. What?
Right.
And let's just kind of talk about that, because I do think not only